Jennifer Williamson, here with Professor Franklin from UCLA. We're going to each do a quick introduction of ourselves, and then I'm going to ask Professor Franklin to tell us about what the Supreme Court did last term around reproductive health care and abortion rights. I'll take a minute to talk about the state of reproductive health care in Oregon, and then we'll open it up for questions. We've got about 45 minutes and lots to cover, and just to quote Judge Ann Aiken from 5 minutes ago, these are cases where there's no records and no facts. So to stay in that vein of thinking, we're going to talk about a couple of cases this afternoon. So as I said, I'm Jennifer Williamson. I come to you by way of the Oregon legislature. I was in the legislature for about a decade. I chaired the Judiciary Committee. I was the Oregon House Majority Leader for 5 years. I was the chief sponsor of the Reproductive Health Equity Act, which we'll be talking about, that was passed in 2017, and served as the interim executive director of Planned Parenthood Advocates of Oregon. So reproductive health care is something that I have worked on since the early 90s in the state of Oregon. And so, Professor Franklin, I'm going to turn it over to you, have you introduce yourself, and then you can just jump right in and talk about what this court's been up to in reproductive health care.
Thanks so much. I hope you all are having a fantastic alumni weekend. I'm so sorry I can't be there with you. School has started in Los Angeles, so we are teaching. I am a constitutional law professor at UCLA, and I'm also the faculty director of the Williamson Institute, which is an LGBT think tank, and also the faculty director of UCLA's Center on Reproductive Health Law and Policy, relevant to the topic of discussion today. And given how short our time is, I think I'm just going to jump right in to talk to you a bit about these cases. There were two reproductive rights cases at the court in the term that just finished. I think if I had to name a theme for this term, I would probably say it was a court that was unafraid to make major change doctrinally to substantial areas of the law. And it was also a court that was unafraid to arrogate more power to itself. That's certainly happening in this area. The court will be deciding a lot of major questions, intervening in a lot of reproductive rights cases, pulling up cases that haven't even yet percolated through the lower courts just to get a jump on them. And without further ado, I will go into the first case that I wanted to talk about today. And that is FDA versus Hippocratic Alliance for Hippocratic Medicine. So, as you all know, in 2022, the court decided in Dobbs that the Constitution does not protect the right to abortion as one of the fundamental liberties that the Constitution guarantees. And as a result of that, the court said the issue will be left to the states can decide it. Roe got the court involved in all of these abortion debates that it really shouldn't have been involved in. Let's leave that to the people, let's leave that to the states. Whatever you think about the substantive constitutional question of whether due process protects the abortion right, the court was wildly wrong that deciding Dobbs would get the matter off the federal court's docket, out of the Supreme Court's hands. Dobbs opened up a Pandora's box of constitutional questions, ensuring that the court will be hearing multiple cases probably every year for the foreseeable future, and that happened this year. One of the cases involved, the FDA case that I mentioned, involved the drug mifepristone. Mifepristone is one of the two drugs used in medication abortion. About 2/3 of abortions in the United States are now medication abortions. You take these two pills, and that's how you implement your abortion. In Northern Europe, it's at about 90% of abortions are medication abortions these days. There's been a major transformation in the landscape of how abortion is provided, particularly in the United States and Europe. And if you are an opponent of abortion and would like to ban the procedure, you really have to go after medication abortion these days, given what I've said about the changing landscape. And that's really the insight behind this FDA case. So in 2000, the Food and Drug Administration approved the use of mifepristone for abortion. Mifepristone is an extremely safe drug. It has a complication rate around the level of Tylenol. So it's one of the lowest complication rate drugs out there, at a much lower complication rate than penicillin or Viagra and many other common drugs. However, the FDA, when it approved the drug, put some very strict regulations on its use. It said that physicians must prescribe and supervise its use. Patients need to visit a physician 3 times to get the pill, and it can only be used up until 7 weeks. That was not an evidence-based determination. That was a politically infused determination that it was subject to the highest level of regulation. In 2016, the FDA reviewed those policies and said these are not appropriate restrictions for this very safe drug from a medical standpoint. And so we are going to remove some of these restrictions. We're going to allow mifepristone to be used up to 10 weeks. We're going to allow physician assistants to nurse practitioners to prescribe it. And we're going to only require 1 visit. Then in 2019, another restriction was lifted. Generic mifepristone was approved by the FDA. And then 2021, after the experience of COVID showed the successful use during telehealth, they removed the in-person visit requirement so that you could get this pill through the mail. Okay. So an alliance of pro-life doctors and organizations, I think including a dentist, filed suit in Amarillo, Texas, challenging the FDA's approval of this drug. These people were not from Amarillo, Texas. Why did they file in Amarillo, Texas? Some of you will know. That's where Matthew Kaczmarek sits as a federal judge. He is a conservative movement lawyer who President Trump appointed to the bench. If you file in this district, you will get him as your judge. So they filed there, and indeed, it worked. Judge Kaczmarek issued a nationwide injunction suspending the FDA's approval of the drug and effectively ordering it off the market. Now, the Supreme Court stayed that injunction while the lawsuit was pending. It got to the Fifth Circuit, and the question was, 1, does this group of doctors have standing to bring this suit? Are they directly affected by it? Are they involved in mifepristone? Are they hurt in any way by the FDA's approval? That was a major question. And then there was and the Fifth Circuit held that they did have standing, and it also held that they were likely to prevail in their challenge against the 2016 and 2021 loosening of the restrictions. Although the FDA had decades and decades of evidence showing the safety of the drug, the Fifth Circuit said, you know, you found that telehealth usage is safe, and you found that nurse practitioners prescribing is safe, but you didn't study what it would be the effect of all of those loosening restrictions together in conjunction. So maybe it's safe to have a nurse practitioner prescribe it, and maybe it's safe to use telehealth, but what if a telehealth visit run by a nurse practitioner yields some kind of complications that we couldn't have anticipated? So that was the Fifth Circuit's holding. This is the first time in United States history a court has ever second-guessed FDA science expert judgment about whether a drug is safe or not. So this goes up to the Supreme Court. Supreme Court grants cert, and the court reversed the Fifth Circuit on the standing question. The Supreme Court held this dentist and these other doctors, they don't administer this drug, they don't use this drug, they don't treat these patients, they've never treated a patient. There's no evidence that in any way the practice of medicine that these medical professionals are engaged in has anything to do with the FDA's approval of this drug. They are not required to perform abortions, they are not required to dispense this drug, they don't dispense this drug, etc. They don't have standing. That does not mean that this case is over. What it means is that this case will come back to the court potentially very soon with new plaintiffs that potentially do have standing. Idaho, Missouri, and Kansas have already tried to intervene in this very case. And we can imagine other cases where maybe you'll have a state plaintiff or some other plaintiff who actually ever handles this drug or could be impacted by this drug. So this got punted, and stay tuned to see what's going to happen. The last note I just want to make about this case is that I don't know if you heard today about the administrative law decisions. I think you may have the administrative law decisions that the Supreme Court issued this term. One of them, Corner Post, is directly related to this case because Corner Post vastly expanded the statute of limitations for facial challenges to government agency actions. It used to be that you have a 5-year statute of limitations. So in this case so far, the FDA's basic approval of this drug in 2000 really wasn't open for challenge because the statute of limitations on the basic approval of the drug had passed. Not anymore. Not anymore. So that not only will the case come back to the court, it will come back to the court with a new claim about the approval in 2000, which Corner Post has now opened up to challenge. Okay, that's the first reproductive rights case. The second reproductive rights case is called Moyle v. United States. This involved a federal law called EMTALA. EMTALA was passed in 1986. And what EMTALA was designed to do is stop the practice of patient dumping. So hospitals, when they got Medicaid patients or patients who could not pay, sometimes they would just refuse to treat them and literally dump them out onto the street, or they would try to transfer them to another hospital and dump them on another hospital so they didn't have to provide uncompensated care. So Congress said, you know, when there are emergency situations where someone needs immediate medical stabilization to save their life, or to say there's a severe health problem that if they don't get immediate treatment, they could be in serious jeopardy. If those are the cases, hospitals are required to provide that emergency treatment. That's what EMTALA said, that if there's an emergency situation, you have to stabilize the patient before you can transfer them or dump them. You have to stabilize them. Okay, and you have to provide what the statute says you have to provide whatever stabilizing care is necessary to stabilize that patient and to alleviate the immediate medical emergency. Roe v. Wade was in place for the last several decades, that EMTALA was also in place. And so hospitals were providing these emergency medical abortions that Roe said you would have to provide, and EMTALA said you have to provide them, and we didn't have a problem. Now, however, Dobbs has come into place, changed the landscape. Lots of states are passing very strict abortion bans, including Idaho, which passed a ban that only allowed abortions if there was an immediate risk to the mother's life. All other abortions are illegal under this Idaho law, including abortions that would save an organ, that would save someone's uterus, that would preserve their fertility, that would, right, serious health conditions. Those abortions necessary for those kinds of health emergencies that don't show an imminent risk of death, those are banned in Idaho. So Idaho said, we're not going to obey EMTALA. We are not going to provide abortions to stabilize people's health. Only to save their life will we provide these abortions. So this case got to the lower court. The district court held that Idaho's ban conflicted with the federal law. The supremacy clause answers this case. The federal law prevails. Idaho cannot institute its ban on emergency health-saving abortions. Federal law requires that Idaho provide those. Idaho appeals. It gets up to the Ninth Circuit. While it's at the Ninth Circuit, the Supreme Court reaches down and says, we're going to take this case. We're not even going to let it percolate through the courts or wait for a decision. We're going to decide it. And they had oral argument. And then this summer, they said, whoops, that was a big mistake. We should not have taken this case. They digged the case. They dismissed it as improvidently granted. They said there were a lot of questions that they didn't have answers to, and they shouldn't have taken the case. Justice Jackson wrote a very impassioned opinion in this case saying, you know, what happened is that because you lifted the injunction and the Idaho law went into place, people have been are being medevaced out of Idaho, and everyone's just crossing their fingers that the helicopter can get to another state quickly enough to save their health, maybe to preserve their fertility, to save their kidney, to save their uterus. We're just hoping that these helicopters can get there in time. At the time of the suit, I think 6 people had been medevaced in the 4 months that the law was in effect. They're anticipating maybe 20 people are going to be rushed to other states via helicopter. That's where we are now. The lower courts are going to have to decide the legal issue, and I can guarantee you this is going to get back up to the Supreme Court, who will issue the ultimate ruling on EMTALA. Those are the cases in a nutshell.
Thank you. All right, so where does reproductive health care stand in the state of Oregon? Oregon's been called the best state for women's reproductive rights in the country, and it's partially because we don't have any restrictions on abortion on the books. No waiting periods, no parental consent. The state also has public funding for abortions, and approximately 78% of women live in a county with an abortion provider in this state, which, as we heard, with medication abortions, it's not as important, but still the number of providers we have is quite high comparatively. Oregon lawmakers and voters have pushed back on abortion restrictions, both in the legislature and at the ballot, regardless of which party has been in power in this state since Roe. But there is no right to reproductive health care in the Oregon Constitution. So after the 2016 presidential election, those of us in the Oregon legislature decided that maybe we needed to put a right to reproductive health care into Oregon law, if nothing else, and to ensure access for folks to the full suite of reproductive health care in the state. So House Bill 3391 in 2017 was known as the Reproductive Health Equity Act, and that expanded coverage for Oregonians to access free reproductive health care services, especially for those who may not have been able to access it at the time. So it required that your health insurance provide coverage for abortion. And if there were issues, for example, you have Providence health insurance, that there were workarounds through the state so that you could access those services even if Providence was unwilling to cover your abortion services and abortion health care. It also, it required no cost sharing, regardless of what that looked like. And it required coverage for trans and gender nonconforming individuals for reproductive health care. So regardless of what your gender assigned at birth was, you have access to the full reproductive health care options. We had issues with folks being turned down for things like cervical cancer screening because their gender at birth and what was on their driver's license didn't match up for somebody who needed cervical cancer screening. So we had to clear that up. It also required coverage for people regardless of their immigration status. So if you were a DACA recipient, you were undocumented, or you had been a permanent lawful resident for less than 5 years, you had access to reproductive health care. One of the things we were finding is that if you were an undocumented woman who had a child, your child had health care, but you were ushered out the door of the hospital the minute you had your child because you were not eligible for coverage because you were undocumented. So we really looked at the full access to reproductive health care in that bill. Fast forward to 2021, one of the issues we were having in the state was actually access to the funds needed, especially in low-income communities, for services, both abortion funding and patient support needs. So the legislature at that time created the Reproductive Health Equity Fund and put $15 million into communities for folks to access both healthcare needs, to bolster healthcare infrastructure, to create community-based advocacy and education programs, and for research dollars. In this last session, so after Dobbs, 2023, House Bill 2002, you may have read about it, watched it, the drama in Salem. That is the bill that shut the legislature down where we now have some state senators who are not allowed to run for re-election because they walked out over that bill. It eventually passed, and what it did was it codified a right, again, to reproductive health care and gender-affirming care. It cleared up some issues around the insurance plan coverage for abortions, where the state had some issues with some of our providers, so it fixed some of those. It also provided protection for providers and individuals receiving reproductive health care and gender-affirming health care services. It made it a crime to interfere with a healthcare facility, and it established the public policy of the state regarding interstate actions involving reproductive health care and gender-affirming care, protecting patient records, and providing that Oregon law governed actions concerning providers and patients and those who assist patients in receiving reproductive health care in Oregon. So as we heard in the EMTALA case, folks were being life-flighted out of Idaho into other states. Oregon was receiving patients from other states and making sure that it was really clear what law governed those patients' access to health care, and if folks were facilitating people's ability to access health care, that they were protected in Oregon. And so that's where we stand right now in Oregon. And so my question, I just want to start out by saying, for example, the mifepristone case. In Oregon, like I said, we have really strong reproductive health care laws, but what kind of risk does the state of Oregon have with the Miffy case coming back up? We know it's going to be back up at the Supreme Court. What should we be thinking about for future challenges to the FDA's approval process, and what could the state be doing to protect Oregonians, both providers and patients, and their access to mifepristone?
Yes, as you describe it, as you nicely described it, Oregon, really, I would say, is leading the entire country on getting out ahead in terms of protecting people's health and thinking through the kinds of legislative protections that need to be in place to make sure that people get the care that they need. Your governor and legislature have, I think, worked together to stockpile
Yes.
a very high level of mifepristone, anticipating what might happen. I think you have stockpiled a couple of years worth of doses.
Yep.
And that is something that California, Washington, New York, and Massachusetts have done. Oregon has done that. So that is one action that states are taking. You have also, I think, importantly, reduced the restrictions that are not evidence-based on the ability to distribute this drug. It's safe to do it via telehealth. It's safe to have physicians' assistants and nurse practitioners dispense this drug. Those are important. Many of the important steps that I described, you have already done. You're kind of ahead of the game. I will say, one thing that happens on the West Coast, sometimes Washington, Oregon, and California get described as a kind of firewall, the states that are protecting reproductive rights, and that can lull people into a false sense of security that these states are, that reproductive care is just assured in these states. And I want to say, kudos to the Oregon legislature and the governor for having the foresight and for working hard to make sure people get care. But there are threats to these Western states as well as the more typical ban states that come through the form of, here's what's so interesting to me from a democracy standpoint. There's not support for a national abortion ban. Congress is not going to be able to pass a national abortion ban. That's wildly unpopular. That's unpopular in every state. That's unpopular among people of both political parties. And there is not anywhere near the votes or the political will, even from the Republicans in Congress, but from anyone in Congress at the current moment. A national abortion ban will not be passed. So what you need to do to try to get at Oregon and California and Massachusetts is get around the people, right? Get around the voters, because the Oregon voters and the national voters are not going to pass a ban. So there are a couple of ways that you can get around the voters. One of them is have the Supreme Court do it. And that's been a big part of the strategy, is to get the Supreme Court to revoke FDA approval for this drug, putting some restrictions on its use and making it harder to get. Another kind of surging strategy that's also a Supreme Court strategy, although it could be a strategy that Trump administration would implement. Project 2025 endorses this strategy, would be to interpret an 1873 law called the Comstock Act, which was an anti-obscenity act intended to stop the distribution of obscene materials. A Trump administration could issue an agency interpretation that interpreted that 1873 law to bar it was a postal law. You can't mail obscenity in the law. Interpret that law to ban the mailing of anything used to procure abortion. That law was never understood or intended to apply to doctors in healthcare settings. It is a misinterpretation of the law, but Justice Thomas and Justice Alito in this case expressed some interest in interpreting Comstock to do that. So one possibility is you can subvert the voters of the current day by either having a Trump administration or a Supreme Court interpret that 1873 obscenity ban to ban the mailing of mifepristone, and that would it's a federal law. It would supersede Oregon law. They could come for the use of this in Oregon. And the other thing I would say, another strategy that's on the table is the personhood movement, to try to convince the court to define fetuses as full human people protected by the 14th Amendment, maybe deciding that abortion violates the rights of these fetal people and must be stopped everywhere. So these are just a few ways that, although I want to say Oregon has worked really hard and is doing, I think, leading the country in trying to make sure that people can still get care, there are limits to what Oregon can do to protect its people.
And we saw that personhood discussion in the EMTALA case, right? Mm-hmm. That the original federal law talked about care to the fetus in a way of making sure that not only the mother's health care in an emergency situation was taken into account when in the dumping situation, but also if she came to the ER because there was something wrong with her fetus. And so I think Justice Alito talks about, well, what about the health of the baby? What about the health of the fetus? Isn't that a competing interest in these cases? And so in the same way that the Comstock Act is mentioned in the FDA case, the personhood conversation really starts in the EMTALA case. And there is some speculation about how these cases didn't even hold the status quo. They really were about losing some ground in that they both allowed these kinds of open discussions of what would be considered setbacks in the reproductive health care movement because it gave oxygen to these discussions about rolling back rights. So it's not all status quo cases are victories right now. So questions, let's open it up for questions. I've got a million of them, but you don't want to hear me.
Is somebody working in Oregon on a constitutional amendment, state constitution, on two things? One, reproductive rights. Two, the definition of person or personhood. And who are they?
So yes, there is a ballot measure being circulated, and I meant to check this morning to see where they were on signature gathering, and I didn't, so forgive me. But I do know that Basic Rights Oregon, Planned Parenthood, the ACLU of Oregon are circulating a ballot measure on a constitutional right for reproductive health care and gender affirming care. And so that their current plan is 2 years from now in the election. So stay tuned for that. I do not know of anyone or any organization working on a personhood ballot measure. But yes, that has been since 2017 a discussion about whether or not the Oregon Constitution needs to be amended to guarantee that right at that level as opposed to just a statutory provision.
Here, have a question since I'm over here.
I'll ask another question.
Go ahead.
So I'm interested in the justices in these two cases and where gender splits the discussion, which I didn't preview this question with you, so sorry if this seems out of the blue. But in reviewing the arguments this morning, it's so interesting to me, especially in the EMTALA case, where we have the male judges talking about procedure and the women justices talking about healthcare. And I'm wondering if that is just me reading into it, but it seemed that the gender balance on the court really made a difference in how concerning it was to the justices, for example, that patients were being airlifted out of the state of Idaho versus whether or not there was an associational standing. And that those were the kind of two tracks of the conversation and the questions of the justices. And I'm wondering if you have thoughts on that.
Yeah, I do. I actually have two answers I will sit side by side to that. And the first one is to say a lot of things look like there's a gender split because what we have is 5 male conservative justices and 3 more progressive female justices. So Justice Kagan, Justice Sotomayor, and Justice Jackson are the more progressive justices, and they're all women. And there's only one person who complicates this gender split, which is Justice Barrett. And I think it's so interesting to look at the polling and the data on gender around reproductive rights, because it turns out that on a lot of the questions, party affiliation is a better predictor of your view of reproductive rights than gender. So Democratic men are generally in favor of reproductive rights and a number of other gender-related, sexuality-related rights, more so in some of these areas than conservative women. So it's a complicated story of politics and gender, and it doesn't just split along men-woman lines. However, I do want to say in the EMTALA case, it was interesting because Justice Barrett was not complete. Justice Gorsuch, Justice Thomas, and Justice Alito, I think, seemed completely sanguine about Idaho's ban. It is fine. You never Idaho should never have to provide an abortion to save people's fertility, to save their organs, to save their health, and there's not a legal problem with Idaho doing that. That's not where Justice Barrett was. She was really asking questions and concerned, I think, of people with ectopic pregnancies and other pregnancy problems in the 9th month who were risking bleeding out, risking losing their uteruses, risking very severe health consequences. And she asked a lot of questions to try to figure out whether those people were going to be put at severe risk, and wasn't willing to go along with the wing of the court that just said this is fine. And I do think, as someone who has given birth to a lot of children, there may have been experiential knowledge funding some of those questions. I think it would be hard to look at that situation. She's a very conservative justice, but she also has had experience with a lot of these issues, and she was expressing a lot of concern about the way that Idaho was treating these people. So yes and no, and it's complicated on the gender question.
Yep.
One of the criticisms of the court over the past few terms is its very lenient stance on standing. such as Masterpiece Cake Shop. But was the standing issue just so egregious in the mifepristone case that they had no choice, or do you think the court, or is there some other reason that the court all of a sudden found religion on that one?
Jennifer, could you just repeat that?
Yeah, sure. The question was standing. So why in this case did the court have an issue with standing when it doesn't seem to have issues with standing generally?
Yeah,
Is
it's
that
taken
fair?
some it's taken some very broad views
Yes.
on standing when it's been convenient.
Yeah.
Yeah, I think that's a really interesting question. I know my colleagues who spend a lot of time teaching standing have to really fight to avoid or perhaps not avoid the impression that standing has just become a completely manipulable doctrine where, you know, there have been some cases where there seems to be real problems and they run roughshod right over that and hear the case. I might flag some of the affirmative action cases as ones where there seem to have been in the past some standing issues that the court did not seem troubled by. But I do think this one is that it was so egregious. I think that this Alliance for Hippocratic Medicine, which again included a dentist and included people who had numerous protections that would mean they would never have to handle this drug or use this drug or dispense this drug, brought this case, and there was just no credible claim. I mean, if you listen to the oral argument, I feel quite bad for the lawyer for them because she had a real hard time. Then again, she shouldn't have come to court with this argument, but she had a real hard time trying to explain how these people could be affected at all by this FDA approval of this medication. So I actually really do think this was a case where it was laughable. It was a 9-0 decision. It was laughable that these people had standing. And I will say, that's going to be corrected. They will be smarter next time. They will have a plaintiff who they can make a plausible case for standing, and this case will be heard by the court sooner rather than later, I would suspect.
Well, my question following on that, though, is that did it allow Justice Kavanaugh I think it was Justice Kavanaugh, to broaden the conscience objection for doctors that some have argued that when the Affordable Care Act was passed, there were amendments to the bill that were never passed by Congress that would have strengthened the conscience objection of doctors to not be able to provide health care, and Congress did not pass those. But Justice Kavanaugh spent time talking about the protections that these doctors and the dentist have in these cases, and opined well beyond what Congress was willing to do to give people the ability to refuse care.
Yeah, so one thing that I think the media generally missed about these cases is, even though we didn't get decisions on the merits, there was a lot of movement with respect to conscious protections. The court, in both cases actually, at oral argument and even in the opinion, expressing a strong view that doctors have very large conscience protections. And I'll identify 2 areas of movement. One, there was a new suggestion, or a amplified suggestion, that not only did doctors have conscience protections, but health institutions generally may have conscience protections. So entire hospitals or hospital systems may have conscience protections to not provide this care. That is something that will be interesting for Oregon. Oregon has one of the highest rates of Catholic hospitals in the country. I think it's about 1/3. And so if there's institutional conscience protection, that would affect a state like Oregon. And so there was an expansion from the individual's conscience to, again, this is not a holding, but the court expressing appreciation for and seeming agreement with the idea that maybe institutions also have these conscience protections. And then I think something that's important in the EMTALA case was that there was discussion at oral argument. EMTALA does not have a conscience exception written into it. If people are bleeding out and literally dying on the table, There isn't a conscious exception in TALA that says you don't have to save them, but Justice Barrett, a number of the justices wanted to establish pretty firmly at the oral argument that there would be a conscious exception in EMTALA. So if you don't feel comfortable, you're a doctor and someone's dying, you can just walk out of the room and let them die. And that is how we interpret EMTALA. So that's significant movement relative to what we had before. Maybe a little in the weeds for the media to cover, but I wish it got out there more. Stay tuned, we'll see more of it.
We've got about 2 minutes left. Yes.
Just a quick follow-up. If the plaintiffs are going to have time to replace the plaintiffs for standing, will the FDA have time to do everything they need to do to get the correct approval for the drug? I mean, they've got decades of evidence. Couldn't they do a meta-analysis of all the studies and get it right?
Well, I have to say the FDA already did all that work. That's already all there. As the studies are done, they are added to the FDA's storehouse of studies, but these drugs have been in very widespread usage for 50 years. So here's something I want to say. These cases trouble me. People have different views of abortion. That's fine. People can have different views of the constitutional protection for abortion. Again, great, that's fine. Let's have arguments about that. Let's discuss the morality and the constitutionality and work out these as a society. People have different views. What worries me the most about these particular cases is the science is very clear. The evidence is very clear. So the FDA has reams of absolutely high quality studies of all of this and has for decades. And I have lawyers who I know coming to court outright misrepresenting data and science, doctors putting false science into the record. It is so important that for our nation's health, forget reproductive rights, in generally, for science, for medicine, for evidence, that not be allowed to proceed. I am very worried about these cases, the FDA case, not just because of its effect on reproductive rights, but because if you have 5 unelected judges who never attended medical school and are not scientists able to countermand the FDA when they don't like a particular drug, regardless of what the science says, that's a very dangerous place to be. And that is what it appears to me this case looks like. Again, we can argue about the morality and the constitutionality, but there is no argument that mifepristone is dangerous. Mifepristone is Tylenol, and that's been shown. That's as old as the hills, and that is so well documented around the entire world. And it's important that the court protect that data and evidence. And I will say it'll be interesting to see how this plays out, because a lot of the big drug companies, big pharma, is on the side of the FDA in protecting mifepristone. They are very concerned about the idea that they could go through billions of dollars of drug testing and development, and then a court could discard that evidence. They do not want that to happen. So big pharma is on the side of the mifepristone protecting people in this case. So I am not sure what the outcome will be. But I do, it's not like the FDA now needs to scramble to gather some data to defend this case. It is there, it has been there, it is not a close case, and I just hope that the science will prevail in this area and other areas.
Thank you so much for that, and for better or worse, we will find out, because these cases are coming back, zombie cases, we will see them again. So thank you, Professor Franklin.
Thanks, Kathy. alumni origin celebration.
Thank you so much, Representative Williamson and Professor Franklin. What a great way to end the day. And thank you, everybody, for attending. Just a real quick item of business. We will be sending out a suggested reading list at the beginning of next week, and we've had some questions about people from other states. If we have your email, we'll follow up with you and see what we can provide you so that you can explore CLE credit in your state. So thank you. Have a great evening.
Thanks for organizing this, Jennifer.
I wish this one had been first. That was so good. It was like, wait. It was really, really good. She's great.
No, she is.